Late yesterday, the political and financial worlds collided in a way few were prepared for. The Manhattan District Attorney's Office quietly unsealed a wave of indictments that instantly changed the legal landscape surrounding Donald Trump's business empire. In a single coordinated action, charges were brought against dozens of individuals tied directly to Trump's inner business circle. Not fringe players, not distant consultants, but longtime operators who helped keep his financial machinery running for decades. Almost immediately, federal buildings tightened security, legal teams scrambled, and major investment firms convened emergency calls to assess their exposure. At the center of this storm is Manhattan District Attorney Alvin Bragg, a prosecutor many critics had written off as cautious, even passive. Since taking office in early 2022, Bragg was often attacked for focusing reform efforts on violent crime while appearing reluctant to pursue high-profile financial cases. For months, commentators accused him of hesitating on the Trump investigation, suggesting political fear or lack of evidence. What few realized was that while public attention drifted elsewhere, prosecutors were methodically assembling a case that would only surface once it was airtight. The investigation itself began years earlier as something far narrower, a limited inquiry into hush money payments and bookkeeping irregularities. But as forensic accountants followed the paper trail, the scope widened dramatically. What emerged, according to prosecutors, was not a collection of isolated violations, but an interconnected financial system designed to move money invisibly, conceal assets, and evade taxes on a massive scale. By the time indictments were finalized, investigators were no longer talking about campaign finance issues alone, but about what they describe as one of the most expansive corporate fraud structures ever uncovered at the state level. The timing could hardly be more damaging for Trump. With plans already underway for a return to political power, his attention was expected to be on policy, staffing, and consolidating influence. Instead, the spotlight shifted instantly back to his business foundation and to the people who know its inner workings best. Court documents describe offshore entities, shell companies, and complex transaction routes stretching across multiple jurisdictions. Money allegedly flowed through layers of domestic LLCs, overseas banks, and foreign intermediaries, obscuring origins and destinations while minimizing tax exposure. Prosecutors say the activity spans decades, not years. Publicly, Trump's legal team reacted with fury. The indictments were branded an extreme form of political persecution, timed deliberately to cripple his political momentum. Statements framed the case as an unprecedented abuse of prosecutorial power, accusing Bragg of weaponizing the justice system. Trump himself amplified those claims online, portraying the investigation as an attack not just on him, but on anyone associated with his administration. But behind closed doors, the mood was very different. According to people familiar with the defense response, the scale of the indictments, both in number and depth, exceeded expectations. What rattled observers across Wall Street was not just the volume of charges, but who responded next. Warren Buffett, famously cautious about commenting on active legal matters, reportedly addressed concerns inside Berkshire Hathaway after reviewing early summaries of the case. His message was blunt. Large-scale financial misconduct rarely stops with the first wave of defendants. When fraud is systemic, exposure tends to spread outward, affecting lenders, partners, and markets that once assumed insulation. That concern explains why financial institutions reacted so quickly. Banks began reassessing relationships linked to Trump-branded properties. Investors quietly reduced exposure. Compliance departments revisited transactions that had once passed routine checks. The fear was not political fallout, but contagion, the possibility that deeply embedded financial arrangements could unravel under legal scrutiny. Prosecutors appear determined to prevent that unraveling from stopping at state borders. Evidence gathered in New York has already triggered cooperation with federal authorities and foreign regulators, expanding the investigation beyond what many initially believed possible. Court hearings have revealed seizures of documents, digital records, and large sums of cash from multiple locations, all pointing toward deliberate coordination rather than accidental misreporting. What this leaves Trump facing is a strategic deadlock. Defending longtime associates risks tying his political future to alleged financial crimes stretching back generations. Distancing himself raises a different problem, acknowledging that the people he trusted to manage his empire may have been operating as a criminal network. Either path carries consequences that go well beyond a courtroom. For now, one thing is clear. This case is no longer about a single defendant or a single election cycle. It is about whether financial power, political influence, and loyalty networks can shield large-scale misconduct from accountability. And as more evidence moves from sealed files into open court, the story is only beginning to unfold. As the scope of the case became clearer, the atmosphere around Trump's operation shifted from outrage to quiet calculation. The indictments were not random or symbolic. They were structured to apply pressure across multiple levels of the organization at once, creating legal exposure for executives, accountants, intermediaries, and facilitators who had long operated out of public view. Prosecutors weren't just targeting outcomes, they were targeting processes, the internal mechanics that allowed money to move without scrutiny year after year. People familiar with the investigation say that what ultimately accelerated the case was cooperation. Once subpoenas began landing and asset freezes followed, some individuals chose self-preservation over loyalty. That decision appears to have opened doors prosecutors had been trying to unlock for years. Financial records that once seemed fragmented began to align. Transactions that looked isolated on paper started forming patterns. What emerged was a picture of coordination so consistent that investigators argue it could not have been accidental. Inside Trump's orbit, the effect has been destabilizing. Longtime allies are now measuring every public statement against potential legal consequences. Silence has replaced bravado in places where confidence once dominated. Even routine political planning has become complicated by legal risk assessments. Every appointment, every public appearance, every internal memo now carries the question of whether it could be subpoenaed later. That kind of environment doesn't just slow decision-making, it paralyzes it. The courtroom developments have only reinforced that sense of gravity. Judges reviewing early filings have indicated that the alleged conduct goes far beyond technical compliance failures. The language used in hearings points to intentional deception, sustained over long periods, with clear financial benefit. That framing matters because it strips away the defense that this was merely aggressive accounting or creative tax planning. Prosecutors are positioning the organization itself as the vehicle of misconduct, not just a backdrop where it happened. Legal analysts note that this approach changes everything. When prosecutors argue that an enterprise functioned as a coordinated fraud mechanism, individual defenses become harder to separate. Each defendant's case becomes entangled with the others. Cooperation becomes more attractive, denial becomes riskier, and the potential for cascading consequences grows with every new disclosure. Markets are paying attention. Even without a direct charge against Trump himself, the uncertainty surrounding his business infrastructure is enough to trigger caution. Investors hate unpredictability, and this case introduces it at scale. The concern is not only about verdicts, but about duration. Prolonged legal battles drain resources, distract leadership, and weaken institutions long before any final judgment is reached. Politically, the fallout is spreading. Lawmakers who once dismissed legal troubles as background noise are now facing constituent questions they can't easily deflect. Calls for accountability are growing louder, not just from opponents, but from voices worried about credibility and governance. The idea that an incoming administration could be shadowed by an expanding criminal case involving its business foundation is forcing uncomfortable conversations in private rooms across Washington. And hovering over all of this is the same unresolved tension: loyalty versus survival. Prosecutors understand that tension well. It is often the lever that breaks the strongest organizations. Every new filing increases pressure on individuals to choose between protecting the collective narrative and protecting themselves. History suggests that, under enough pressure, the collective rarely wins. What makes this moment especially consequential is that it arrives at a time when trust in institutions is already fragile. The outcome will influence not only Trump's future, but how aggressively the justice system is willing to pursue complex financial crime tied to political power. If this case stalls, it will reinforce cynicism. If it advances, it will redefine expectations. Either way, the direction is clear. The indictments were not an endpoint, they were an opening move, and the machinery behind them is still turning. What follows next is the phase prosecutors care about most, and fear spreads fastest through. Once indictments are public and the initial shock wears off, the process turns slow, methodical, and relentless. Discovery begins. Financial records are compared across jurisdictions. Communication logs are reconstructed, timelines are aligned. This is where narratives collapse because documents don't argue back and spreadsheets don't forget. Sources close to the case say investigators are now less interested in what defendants say publicly and far more focused on what they said to each other when they believed no one was watching. Encrypted messages, internal emails, handwritten notes attached to transactions, all of it becomes part of a mosaic designed to show intent. Prosecutors aren't trying to prove that mistakes were made. They're trying to prove that deception was the operating model. That shift has profound consequences for everyone still inside Trump's orbit. Loyalty, once rewarded, becomes dangerous. Silence, once protective, becomes suspicious. Every individual must now assume that someone else has already talked or is preparing to. This is how large cases metastasize, not through dramatic confessions, but through incremental disclosures that slowly box in anyone still holding out. The pressure is compounded by the way these cases interact with each other. State charges create leverage for federal cooperation. Financial crimes unlock tax exposure. Tax exposure opens the door to bank fraud. Bank fraud leads to international inquiries. Each step expands jurisdiction and shrinks the room to maneuver. What might have been survivable as a single case becomes overwhelming when stacked across systems that were never designed to be navigated simultaneously. Inside financial circles, the tone has shifted from curiosity to caution. Institutions that once assumed they were insulated by distance or legality are reassessing past interactions. The question isn't whether they did anything wrong, but whether they can afford to be adjacent to something that might explode later. Reputational risk moves faster than legal risk, and it doesn't wait for verdicts. For Trump personally, the situation is uniquely constraining. Even without a direct indictment, his ability to operate depends on people who are now under extraordinary pressure. Decision-making slows. Trust erodes. Every move is filtered through lawyers. That is not how effective power is exercised. It is how power becomes reactive, defensive, and brittle. Politically, the long-term danger is not a single headline or even a single conviction. It's erosion. Each week that brings new filings, new disclosures, or new cooperating witnesses chips away at the argument that this is all noise. At some point, volume becomes substance. Repetition becomes reality. And once that threshold is crossed, the story stops being about partisan interpretation and starts being about institutional credibility. This is why experienced observers aren't asking how Trump will respond tomorrow. They're asking how long this can continue without something fundamental giving way. Large, complex fraud cases rarely end with a clean break. They end with exhaustion, financial, political, and personal. Organizations fracture, alliances dissolve, the center cannot hold forever. What's unfolding now is not a sudden collapse, but a controlled demolition. Each step looks manageable on its own. Together, they reshape the landscape. And as more evidence moves from sealed filings into open court, the question is no longer whether this investigation will expand, but how far and who will still be standing when it does. As this phase deepens, the investigation begins to take on a momentum of its own. Prosecutors no longer need dramatic announcements to keep the case alive. The process itself becomes the pressure. Every scheduled hearing forces defendants to confront timelines they can't control. Every discovery deadline brings the risk of another document surfacing that contradicts a public denial or exposes a private assurance. This is the grind that large organizations struggle to survive because it leaves no room for spectacle, only endurance. What's particularly destabilizing is how uneven the risk has become across Trump's former inner circle. Some individuals face limited exposure and may see cooperation as a way out. Others are staring at decades of potential liability and have far more incentive to trade information for leniency. That imbalance fractures unity. Even if everyone wanted to hold the line, the incentives are no longer aligned. Prosecutors understand this dynamic well. They don't need everyone to flip. They only need a few key insiders to begin validating the structure of the case. As that happens, the narrative shifts again. Defense strategies that once focused on discrediting motives or questioning jurisdictions start to sound thin when corroborating evidence piles up from multiple sources. Judges become less patient with procedural delays. Courts prioritize efficiency over theatrics. The room for maneuver narrows, and what once looked like a political fight increasingly resembles a technical reckoning with facts that are difficult to explain away. Outside the courtroom, the implications continue to ripple. Corporate boards, lenders, and partners recalibrate their relationships based on risk assessments rather than loyalty. Projects are paused. Financing terms tighten. Associations that once seemed routine now carry reputational cost. This quiet disengagement often does more damage than any verdict because it hollows out an organization long before legal conclusions are reached. For the broader political environment, the case is becoming a slow-moving backdrop that influences behavior without dominating headlines every day. Lawmakers hedge. Allies distance themselves just enough to maintain plausible deniability. Conversations that once assumed continuity now include contingency planning. That subtle shift is often how power wanes, not through a single decisive blow, but through accumulated doubt. What makes this moment especially consequential is that it tests the durability of systems designed to be impartial. Prosecutors are under scrutiny. Courts are under scrutiny. Every decision is dissected for motive as well as merit. Yet the machinery keeps moving forward, driven less by ideology than by procedure. That more than anything is what gives the process weight. It is not reactive. It is institutional. As more evidence enters the public record, the remaining question is not whether the investigation has altered the landscape. It already has. The question is whether it ultimately reinforces the principle that complexity and power do not place anyone beyond accountability, or whether it stalls under its own scale. The answer will shape expectations far beyond this case, influencing how future prosecutors, executives, and politicians calculate risk. For now, the trajectory remains clear. The indictments were not the climax. They were the moment the curtain rose on a much longer act. And as the legal machinery continues its steady advance, those still tied to the center of this story are learning a difficult lesson. Once momentum shifts from narrative to evidence, it rarely reverses. What lies ahead is the part of the process that rarely makes headlines, but ultimately determines outcomes. As calendars fill with hearings and filings, the investigation transitions from exposure to consolidation. Prosecutors begin locking in testimony, narrowing contradictions, and formalizing timelines that leave little room for reinterpretation. At this stage, defenses stop being about innocence and start being about damage control. The question shifts from "did this happen?" to "how much of this can be proven and against whom?" For those still connected to Trump's business network, the psychological toll is becoming as significant as the legal one. Careers built over decades are now reduced to risk profiles. Long-standing relationships are re-examined through the lens of liability. People who once trusted that discretion and loyalty would protect them are discovering that those same qualities now make them vulnerable. In complex financial cases, proximity is not protection. It is exposure. The investigation is also forcing a reckoning inside institutions that intersected with Trump's empire without ever considering themselves part of it. Accounting firms, lenders, insurers, and intermediaries are reviewing old decisions with new urgency. Even actions that were legal at the time are being scrutinized for context, intent, and omission. The fear is not necessarily prosecution, but association. In modern finance, reputational fallout often precedes legal consequences, and it can be just as destructive. Politically, the slow drip of developments is altering expectations. Allies who once dismissed legal trouble as noise are recalibrating. Opponents are becoming more disciplined, allowing the process to speak for itself rather than overreaching. The case no longer needs exaggeration, its sheer persistence is doing the work. Each additional filing reinforces the perception that this is not a temporary distraction but a structural challenge with no quick resolution. What makes this moment especially revealing is how little control any one person now has over the outcome. Trump can shape rhetoric but not discovery. Lawyers can argue motions but not erase documents. Political pressure can influence public opinion but not accounting records. The system, once set in motion at this scale, operates on timelines that are stubbornly indifferent to ambition or narrative. As months pass, the investigation's true impact will likely be measured less in verdicts than in precedents. How aggressively financial crime tied to political power is pursued. How insulated business empires really are from accountability. How resilient legal institutions remain when pressure comes from every direction at once. These are questions that will outlive the individuals involved. For now, the trajectory remains unchanged. The process continues, method by method, filing by filing. There is no dramatic finale yet, only accumulation. And in cases like this, accumulation is everything. Once enough weight is added, outcomes stop being a matter of strategy and start becoming a matter of inevitability.